Imagine investing in a valuable property in Vietnam. You provide the money, you choose someone you trust, you sign an agreement confirming that the property belongs to you. Everything appears protected, but years later, that same arrangement becomes the reason you are fighting to recover your own asset. This is the hidden danger of nominee agreements in Vietnam. Many foreign investors use nominee structures because they believe they are a practical solution to ownership challenges. But a document that looks protective on paper may create unexpected legal risks if it is not carefully structured. Today, we will explain why nominee agreements can backfire on foreign owners in Vietnam and how investors can better protect their interests. Nominee arrangements usually appear because foreign investors face certain restrictions or practical difficulties. For example, a foreign buyer wants to acquire property. A foreign investor wants a local person to temporarily hold an asset. A business structure requires a Vietnamese shareholder, or administrative procedures appear easier through a local representative. The nominee relationship is often based on trust: a friend, a business partner, a spouse, or a family member. At the beginning, everything may work smoothly. The investor provides the funds, the nominee holds the legal documents. Both parties understand the arrangement. However, problems often appear when circumstances change. One of the biggest risks with nominee arrangements is the difference between beneficial ownership and legal ownership. The investor may believe, "I paid for the asset, therefore it belongs to me." However, official records and registered ownership can become extremely important when disputes occur. If the nominee's name appears on official documents, that person may have legal rights recognized by authorities. A private agreement between the parties may provide evidence of the relationship. But enforcement can become complicated depending on the circumstances, documentation, and applicable laws. This is why nominee arrangements require careful legal analysis before they are created. Many investors believe a nominee agreement solves everything, but poorly prepared agreements can create additional problems. Common issues include unclear ownership rights, weak transfer obligations, insufficient evidence of payment, missing dispute resolution mechanisms, unclear responsibilities of the nominee, or terms that conflict with Vietnamese regulations. A nominee agreement should not simply record trust between two parties. It should anticipate what happens if trust disappears, because legal documents are most valuable when relationships become difficult. Many nominee disputes begin with a simple change in circumstances. The nominee gets married. The nominee experiences financial problems. The relationship between the parties breaks down. The nominee's family challenges the arrangement. The nominee refuses to transfer the asset. What seemed like a simple solution can become a complicated legal dispute. Foreign investors are particularly vulnerable because they may live overseas, may not fully understand local procedures, and may face difficulties collecting evidence or enforcing their rights. The first mistake is relying only on trust. Trust is important, but valuable assets require legal protection. The second mistake is using generic agreements from the internet. Every nominee arrangement has different risks depending on the asset, relationship, and investment purpose. The third mistake is waiting until a dispute occurs. Once a conflict begins, negotiation becomes more difficult, and recovery may require significant time and resources. Proper planning before entering the arrangement is always more effective. If a nominee structure is being considered, investors should carefully evaluate alternatives and understand the risks. Important considerations include verifying the nominee's background and circumstances, preparing comprehensive legal documentation, maintaining evidence of financial contributions, clearly defining obligations and responsibilities, planning for transfer, exit, and dispute scenarios. Professional legal advice helps investors understand whether a nominee structure is appropriate and how risks can be reduced. At LTS Law, we assist foreign investors with complex ownership and nominee-related matters in Vietnam. Our support includes reviewing existing nominee arrangements, preparing legal documents and supporting materials, assessing ownership risks, advising on alternative structures, negotiating with relevant parties, and representing clients in disputes when necessary. Our focus is not only preparing documents, our focus is protecting the investor's long-term interests. Recovering an asset after a nominee dispute can be challenging. The best strategy is prevention. Before transferring money or allowing someone else to hold ownership, investors should understand what rights they have, what risks exist, what protections are available, and what happens if the relationship fails. Sophisticated investors do not rely only on trust, they build legal protection around their investments. Nominee arrangements may appear convenient, but convenience without proper legal planning can create significant risks. If you are a foreign investor considering using a nominee structure in Vietnam, or if you're already involved in a nominee arrangement, professional legal advice is essential. At LTS Law, we help foreign owners evaluate risks, protect their assets, and develop practical legal strategies. Book a consultation with LTS Law today, because protecting your investment should begin before a dispute starts.